My name is Nomfundo Jele from the Law Society of South Africa. I'm joined by Ugeshnee Naicker, who sits on the Law Society's House of Constituents, and we'll be discussing the Divorce Backlog Project. Welcome, Ugesh.
Thank you, Nomfundo.
The purpose of the project is to fast-track unopposed and settled divorces to get finalized and to fast-track opposed divorces through the possibility of mediation. This video will focus on the appointment of liquidators and receivers in divorce matters. Okay, Ugesh, can you please tell us what happens if a divorce order relating to the division of a joint estate was granted, but the parties are unable to divide the estate?
Nomfundo, in the case of M versus M in 2018, the court confirmed that where the parties are unable to agree on how to divide the estate, the duty devolves upon the court to divide the estate. And the court has the power to appoint some person to effect that division on its behalf. The court has the power to nominate and empower someone to collect, realize, and divide the estate. This has been the practice in South African courts. In Mirage versus Mirage and others in 2002, the court stated that the parties are entitled, of course, to agree on the manner of division. If they cannot agree, a liquidator may have to be appointed.
All right, thanks for that, Ugesh. And what is the procedure to get a liquidator appointed?
This involves an application to court. So the person who wants to appoint a liquidator must make an application to court. In the matter of L versus S in 2015, the court stated that amongst other, a court needs to properly assess whether the joint estate ought to be burdened with the appointment of a receiver and a liquidator. And a judicial officer ought to generally strive to ensure that he or she has a complete set of papers before him or her, as possible, in order to properly understand the case over which he or she is required to make a decision. This means that the applicant must demonstrate his or her entitlement to an order for the appointment of a receiver and a liquidator. If the judicial officer receives an incomplete set of papers, it prevents the judicial officer from fully appreciating the real issues between the parties, with the result that the decision is ultimately rendered an incorrect decision.
Thanks, Ugesh. Can the parties agree to the identity of the liquidators? And what happens if they do not agree as to who should be the liquidator?
Nomfundo, yes, the parties may agree to a specifically identified person. If they do not agree, the court is not necessarily required to appoint a specifically identified person. However, it is the duty of the court to appoint an impartial person. In the matter of M versus M, a 2018 judgment, the court stated that where the parties cannot agree to the identity of a receiver and liquidator, and where valid objections are raised to the person suggested by the parties, the submission on behalf of the applicant will have it that the court must now embark on a process to find an impartial person. The immediate question that arises is who will attend to obtaining the necessary consent to act. Surely that cannot be the function of a judicial officer. In appropriate circumstances, I see no good reason why the court cannot order the appointment of an impartial person, the identity of which is to be determined by someone such as the chairperson of the South African Institute of Chartered Accountants. This I understand to be the practice in this division, in order to avoid allegations of bias during the course of effecting the division of the joint estate.
Thank you, Ugesh. And what powers are normally given to the liquidator and receiver?
In the Supreme Court of Appeal case, in the matter of Ndaba versus Ndaba, reported in 2016, it provided some indication of the kind of powers and duties that are ordinarily granted to the liquidator or receiver, which include, for example, the right to make all investigations necessary, and in particular, to obtain from the parties all information with regard to the assets comprising the joint estate. the right to obtain information regarding their financial affairs from bank managers, building societies, managers, and any other official institutions where monies have been invested. The right to obtain information from auditors or private companies or business and personal accountants with regard to personal affairs and tax matters, and any other person who may have knowledge of the affairs. The right to obtain and call for balance sheets in respect of all companies or businesses in which the parties have interest. The right to inspect books of account in respect of any company or business where the parties may have an interest, and also the right to inspect personal bank statements, paid checks, deposit books, and personal statements of affairs and liabilities which may have been drawn for tax and other purposes. One can peruse the judgment for further examples, but each application will have to be considered taking into account its unique circumstances. That means it will be considered on a case-by-case basis.
Thanks so much for your time. Thanks, Ugesh.